Good night. This is U.S. Immigration Attorney Sharifa Tharpe. I am here live to take your U.S. immigration related questions, and I have a great topic to talk to you about tonight. So I'm going to be talking about how one can apply for stepchildren and step-parents. Yes, that is a thing. Yes, U.S. citizens or residents can apply for their stepchildren and children. So adult stepchildren can apply for their step-parents. So I'm going to talk about that tonight. And what I want you to know, though, is that you can put your questions in the comments and I will answer your questions. It does not have to be related to the particular topic that I'm talking about. It can be anything that's immigration related. You can go ahead and put it in the comments while I talk about this topic tonight. So yes, even though the stepchild or the step-parent are not related by blood, it is still a possibility under immigration law to apply for a step-parent or a stepchild. Now, under immigration law, you have to meet the definition of who a stepchild is. It's very specific. So it doesn't just mean that, okay, if my parent is married to a U.S. citizen or a resident, I automatically get stepchild or step-parent status under immigration law. No, you have to be, if you're the stepchild, you have to be under 18 at the time that your parent and your U.S. citizen or resident step-parent got married. If you were over 18, then unfortunately you would not qualify as a stepchild or a step-parent for immigration purposes. However, if you do fall under that category, then it means that your U.S. citizen or resident parent or your child may be able to apply for you. Now let's start with a stepchild. How does this work? How can a step-parent, U.S. citizen or resident parent apply for a stepchild? Pretty much the same way that you can apply for a regular child, like your biological child or your adopted child. Right? You have to, as a U.S. citizen, for example, let's start with the U.S. citizen. A U.S. citizen can apply for their stepchild who is under 21 and unmarried, and that stepchild would have priority in the green card process. So that means that it would be a faster process. A stepchild would be able to do adjustment of status in the United States, even if out of status, if they're under 21 and unmarried, because that means that they are the immediate relative of a U.S. citizen, only the stepchild of a U.S. citizen. Now, what if you are 21 and over, right? Then you're going to fall into a different category. It doesn't mean that your step-parent can't apply for you. No, I'm just going to give you another reminder here for those who are just joining in, that a stepchild, a step-parent under immigration law is one who is the child was under 18 at the time that the parents got married. So that the parent got married to the U.S. citizen or the resident. If you were over 18 or you were 18 or over, you would not qualify under immigration law as a stepchild. So that's the very important detail that you can't miss with this, is that because generally if a parent gets married to another person, you consider that person a step parent, no matter what your age is. However, under immigration law, it's only limited to if the parents got married before the child was 18. Now, if you are the stepchild, right, and you are now 21 or over and you didn't file when you were supposed to, or your step-parent didn't file for you when you were under 21, then you would still qualify for permanent residence through your step-parent, but you would have to then show you would then have to wait for a longer period of time, because the process for anybody who is the child of a U.S. citizen, it's taking, unmarried child of a U.S. citizen is taking 6 to 7 years. So if you're the unmarried son, stepson or daughter of a U.S. citizen, and you're 21 or over, you're looking at a 6 to 7 year process, the same as if you were the biological or adopted child of a U.S. citizen. So what the point I'm trying to make is that if you are 21 and over, you're not disqualified from still applying through your step parent, but you will have to wait a while longer. And it's also going to depend on your marital status. So a U.S. citizen step parent can apply for you as long as you meet the definition of stepchild under immigration law. As long as you're unmarried, it's going to take 6 to 7 years. But if you're married, then that turns into a 12-year process. And now the same goes for a resident. Residents can apply for their stepchildren. Now, when here's the benefit with a resident applying for a spouse. If the resident is applying for the spouse and that spouse has children who are under 21 and unmarried, they don't have to file a separate application anyway. And so anybody who's under 21 and unmarried, they can be included in the application. Now, if the stepchild of a green card holder is 21 or over, then it's going to be a longer process, and they have to be unmarried. So similar to the regular biological or adopted child of a resident, they have to be unmarried. Green card holders can't apply for married children, and that still applies to stepchildren. Now, what about step siblings? Can step siblings apply? And the answer is yes, step siblings can apply for their siblings. That is surprising, right? That as long as, once again, the parents that they have in common were married before before the person that's being sponsored turned 18, they became a step family. Then in that case, that sibling could apply, the step sibling could apply for the other sibling. So these are surprising details that you should know about, right? Because a lot of people think if they have a step sister, step brother, step sibling relationship, a step parent or step child relationship, that they would not qualify, and they can. The step sibling just has to be 21 and up to be able to apply. And, they would have to still show the relationship. So they would still have to show that they have the relationship through their parents that got married before the applicant turned 18 years old. So what if the parents got divorced? Does that end the relationship, right? And the surprising answer here is it doesn't have to, and it really comes down to your facts. If you continue to maintain a bona fide relationship with your step parent or your step sibling, then at that point they can still apply for you to get permanent residence. But now there's the added element of showing that you continue to maintain this relationship with your step parent despite the divorce. But it's not impossible. Whether you qualify, though, is going to come down to whether the facts in your case, circumstances in your case, and how things went down. Now, just whether you can stay here and apply or you'd have to do consular processing is going to depend on your background. Are you here? Are you out of status? Are you the immediate relative of a U.S. citizen? Because remember, if you're the immediate relative of a U.S. citizen, so that means you're the step child under 21 and unmarried of a U.S. citizen, then that means that you could very well stay here and apply for adjustment of status, get the work permit, and move forward without the need to leave. But if you're 21 or over it's unlikely you would be able to qualify unless you qualify through VAWA, where the step parent mistreated you, and now you are trying to apply through the VAWA to get the work permit and adjust status that way. So there are different elements, different moving parts to this, just depending on what's going on in your case. But what the takeaway I want you to get here is that, hi there, Sophia, it's nice to see you, is that when there is a step relationship, it doesn't preclude them from applying for you. You can apply through your step parent. You can apply for your step parent, or you could be sponsored by your step parent. And so that does provide additional options for some, and you just have to know that this option exists. So I don't see any questions so far, and I'm pretty much finishing up this topic of being the step parent, being the stepchild, being the step sibling of U.S. citizen or resident. Whether you qualify, and the answer is yes, you qualify. You may very well qualify for permanent residence through a step parent, through a stepchild, or son or daughter, through a step sibling. So, or a half brother and sister. Since we're talking about siblings, half brothers and sisters can also apply for their siblings, as long as that U.S. citizen, as long as the sibling is a U.S. citizen and they're 21 and up, they can apply for you. Now, what if you have a step parent? As long as I said before, very important that you know that you have to be, in order for the step parent, step child relationship to exist, the child would have had to get, the parents would have had to get married before the child turned 18. And so if you're the U.S. citizen and you would like to now sponsor your step parent, that is a possibility as long as you were under 18 when your parents got married. Then that parent would have priority in the green card process, which would take, right now it's taking about 18 to 24 months to go through. So what are your thoughts about boundless immigration? So Brittany, I don't have any thoughts on them. That is up to you to decide what services you would like to pursue. But I only have opinions about the service that I provide to my clients, and I'm confident in my representation, my complete and detailed, thorough representation of my clients. I aim for results, and I do everything in my power to make that happen for my clients, but I can't speak to anybody else's services. When you plead asylum, will the judge accept email documents from witness, or I have to have originals? So I am Merica Brown. That gets into civil procedure, and I would have to be your attorney to talk to you about that. So I cannot provide you legal advice that is extremely specific about what the judge will or will not accept, and so I would not be able to advise you on that. That is something that I would deal with during the representation of my client. So at Itanist, good evening. It's nice to see you. Or Itanist, it's nice to see you. Thanks for saying hello. So I don't see any more questions, and that is all the information I have for you tonight. I hope this was helpful to you, and I will be back tomorrow at 9:30 p.m. Eastern Time. Remember, if you would like personal legal advice, it's very important that you go to the link in my bio, schedule a consultation first, and then we can talk about your situation and determine what you need to do and whether you need representation. So I see some questions here. Want to apply for my child abroad? How do I go about it? So you'd have to apply for the relevant forms with the relevant evidence and go through the different stages of the process. So first there's filing the I-130 petition along with additional forms, just depending on what's going on in your case. And then and that's if you're a U.S. citizen, or a permanent resident. You can apply for your child. However, if you just have a visa, or if you have an employment-based visa, your child should be included or should be able to obtain the visa based. It just depends on what type of visa you have. But if you're a U.S. citizen or a resident, then you would be able to apply for your child. You'd have to file the relevant forms. And then once it's approved, it goes to the National Visa Center. That's where I work with the National Visa Center to submit the relevant documents, and then it gets scheduled for the interview for your child. So Itennis, if you would like to go ahead, schedule a consultation, highly encourage you to do that so that you can get the right information, won't make any mistakes, and get the representation you need. Get that burden off of you and have somebody who knows what they're doing do it for you. Would doing a fiancé visa be easier or faster? So Sad Queen 22, what I usually say is when you hire an attorney such as myself, it does make the process easier, and it could possibly make the process faster, just because the attorney understands what is required and can get it done quickly, efficiently, and submit the right information and documents. Where I find that sometimes I get consultations where people think that this is just paperwork, that they're just going to do it on their own, and they end up in neck deep situations where it just keeps getting worse and worse for them, and they end up in trouble with a denial or delay process. And so an attorney, by understanding the process, being able to help you navigate complex issues, can help you through the process in an easier way, becomes easier for you especially, and can be faster because the attorney is providing the information that the immigration officers need to make decisions. While an attorney, if you hear an attorney say, hire me, I'll make your process faster, that's not an attorney you want to go with. No attorney can guarantee to make your immigration process faster. And keep in mind, just by nature right now, the immigration process is moving slower, and it has nothing to do with the attorney. It has everything to do with just the processing times of the service centers. Right now, for fiancé visas, it's taking a little over a year for these to be processed. And God forbid you enter the process and then make mistakes and get delayed even further. So that is where it's very important to schedule a consultation and get the help you need to make sure that you're doing the process the right way. Can my child obtain citizenship if I become a citizen even though she lives abroad? So usually they would have to meet certain requirements. So that child would also have to be a permanent resident in order to then derive citizenship from you after you become a citizen. But after she becomes, or your child after you become a citizen and then your child comes into the country and becomes a permanent resident, at that point they would be able to derive citizenship. And Itennis, I'm looking forward to hearing from you. So great questions so far. Thanks so much everyone for your questions. Go ahead and contact me to schedule the consultation. For those of you who ask questions, I highly recommend, if you are thinking about or concerned about something in your particular situation, that you schedule the consultation and then let's talk about it so that I can advise you personally. Because remember, the information that I'm giving you tonight is general information. It's not personal legal advice. So you should not be acting on this information until you sit down with an immigration attorney and get it straight from their mouth and get your particular details out so that you can personally understand what you need to do to succeed in your process. Thanks so much, everyone. So have a good night. I'll see you tomorrow at around 9:30 p.m. Eastern. Have a good one, guys.